Today we will see Class 12 Legal Studies Unit 6 Legal Services. In the state of nature, indeed, all men are born equal, but they cannot continue in this equality. Society makes them lose it and they recover it only by the production of laws. Charles D. Mandelsky. Introduction. According to Encyclopedia Britannica, legal aid is given to the persons of limited means, grants or for nominal fees, advice or counsel to represent them in court for civil and criminal matters. It aims to create a bridge between the poor and rich in the society in order to provide equality to seek justice in the court of law. Rogel's the first principles of justice is that each person should have an equal right to the system of equal basic liberties. Legal aid is ensured that no one is debarred from legal advice and help because of lack of funds. Thus, the provision of legal aid to the poor is based on the humanitarian consideration, and the main aim of these provisions is to help those who are socially and economically backward. Reynold Herbert Smith, in his 1990 book Justice and the Poor, promoted for the first time the concept of free legal assistance for the poor. Smith challenged the legal professions to consider it an obligation to make sure that justice was accessible to all, without regard to the ability to pay, without equal access to the law. He wrote, "The system not only robs the poor of other only production, but it places in the hands of their oppressors the most powerful and ruthless weapon even invented." A brief history of legal services. The growth of the legal aid movement is seen as one of the late conscious attempts in social adjustment that followed the slow and often unconscious process of social engineering. The real problem of social engineering was stated clearly when Hammurabi, the king of Babylon, announced his purpose of promulgating the code which he set up in the early years of the 20th century BC. That purpose was to establish the justice in the earth, to hold back the strong from oppressing the weak. Such social adjustment is also referred to as social engineering. Social engineering may be defined as the science and art of making appropriate adjustment to human relationship as well as to promote the welfare of the community as a whole. In the savage struggle for existence, it is natural for the strong to take advantage of their strength. Of this adjustment, the most necessary as well as the most difficult is clearly indicated by the words of the wise autocrat of Babylonia. It is to prevent the strong from oppressing and exploiting the weak. Here they give the code of Hammurabi, written nearly 4,000 years ago, had progressive laws such as minimum wage, the right to be born a free man, the need to work off your debt, and no injustice. This was written 2,000 years before the Bible. There were three processes whereby the developing civilization progressively moved towards the social engineering through a free legal aid. The first was to grant aid to vulnerable communities. The Second was to put the restrictions upon the exercise of privileges accorded by law of those well off. And the third was to strip those fortunate of their privileges and place the strong and weak on an equal footing before the law. But these three steps do not ultimately bring the society towards realizing its goal. There is one end of weakness that is not adequately protected by the restraints or by taking away the privileges from the fortunate. As law is not self-executing, the power of the society which gives the sanction to law must be brought to bear upon the law breaker before a wrong done is made right. The process of setting the machineries of the law in motion involves effort as well as expense. Those economically weak cannot bear this expense, and hence we are to ask ourselves, what does it profit a poor and ignorant man that he is equal to his strong antagonist before the law? Antagonist before the law, or are the courts open to him on the same terms as to all other persons when she has not the wherewithal to pay the fee? From the earliest times, there is the evidence that lawmakers had censored the disability of the poor. They had attested that the disability must be taken into account in any sound scheme of social engineering. Thus, the Code of Hammurabi attempts to limit the charges made for the services to the poor men, providing an existence wherein a surgeon can exact subjectively from the poor and the rich. Mosaic Law (Law of Moses) gave to the poor man many privileges, intending to aid him to escape from the bonds of debt and servitude. If the creditor took his poor debitor's clock in the village, he must return it by nightfall, for instance, otherwise he would have no covering for the night. So prompt payment of wages to the poor was enjoined, for he was poor. Here Herodotus. According to Herodotus, justice in Egypt was administered without cost in order to give the greatest relief possible to those who were wronged. It is evident that court costs constitute the most obvious obstacle to the poor man seeking justice. Despite Herodotus' statement with respect to Egypt, it is probable that costs in some form have always been required of litigants. It may be that in early times, when the Hebrew courts sat by the city gate, there was a free and easy access to all the suitors, but the Pharisees' charges of the sale of justice made by the prophets suggest the toll of the heavy costs. Under the peculiar procedure before the praetor at Rome, cost took the form of the odimonium, security for the appearance by the defendant, and the sacramentum, which was in the form of wager laid by each party, but in substance security to abide by the judgment of the court. No evidence is found of any special procedure by which a person too poor to bear these changes could secure the adjustigation of his claims. In the early years from 1876 to 1965, civil legal assistance for the poor people in the United States began in New York City in 1876 with the founding of the Legal Aid Society of New York. The legal aid movement caught on in urban areas. By 1965, virtually every major city had some kind of program. 157 organizations had employed over 400 full-time lawyers with an aggregate budget of nearly $4.5 million. There was no national program as such. Since 1952, the Government of India also started addressing the question of legal aid for the poor in various conferences of law ministers and law commissions. In 1960s, some guidelines were drawn by the government for legal aid schemes. In different states, legal aid schemes were regulated through the legal aid boards, societies, and law departments. Although all are equal before the law, in practice some seem to be more equal than others, and this resulted in the denial of easily available opportunities to access justice. Article 39A of the Constitution, inserted by the 42 and Amendment Act in 1976, offered a remedy to this problem by directing the state to provide free legal aid by suitable legislation or schemes or any other way, to ensure that the opportunities to secure justice are not denied to any citizen by reason of economic or other disabilities. Legal aid schemes were floated across states through the legal aid boards, societies, and law departments thereafter. See legal background. In a participatory democracy, it is essential that citizens have the faith in their institution. A judiciary that is as fair and independent is an important component in sustaining their trust and confidence. An impartial, independent judiciary is the guarantee of the individual rights in a democratic society. In order for citizens to have faith in their court system, all people must have the access to the courts when necessary. Citizens agreed to a limitation on their freedom in exchange for peaceful coexistence, and they accept that when conflicts between the citizens or between the state and the citizens arise, there is a place that is independent from undue influence, that is trustworthy, and it has an authority over all the parties to solve the disputes peacefully. It is also the responsibility of the state to ensure that the fair and the impartial justice is made available at the doorsteps of the poor and economically weaker section, irrespective of their caste, creed, religion, geographical position, or at free of cost. The fundamental value of Indian system of justice is that the stability of our society depends upon the ability of the people to readily obtain access to courts, because the court system is a mechanism recognized and accepted by all to peacefully resolve disputes. Gaining access to the courts forces dispute resolution into other arenas and result in vigilation and violence, as envisaged under the Article 15 of the Constitution of India. The state shall not discriminate against any citizen on grounds of religion, race, caste, sex, birth of place, or any of them. Based on this cardinal principle, no citizen shall, on the grounds only of religion, race, caste, sex, place of birth, or any of them, be the subject to any disabilities. Article 14 of the Constitution of India provides that the state shall not deny to any person equality before the law or the equal protection of the laws within the territories of India. Human rights and the human dignity form the premises of the socio-legal foundation of the free legal age. As part of the human right, it is necessary to recognize the principles of equality and ensure the access to justice. These foundations reflect the incorporation of the legal obligation in the international treaties, regional treaties, the working of the monitoring bodies under these treaties or in the national legal system. Thank you. Sharing is caring. Comment your thoughts. Subscribe for more knowledge.